Hello, and welcome to Law Logical, your weekly source for everything you need to know about the world of law. Today, we're diving into a major update in India's legal system, the recent amendments to the Arbitration and Conciliation Act. Whether you're a business owner, legal professional, or just curious about how disputes are resolved outside the courtroom, this episode is for you. To kick things off, let's quickly cover what arbitration actually is. Arbitration is an alternative dispute resolution mechanism designed to handle conflicts outside of the traditional court system. It's faster, more flexible, and confidential. Plus, parties can choose their arbitrators, making the process more specialized compared to going through the courts. In a country like India, where court cases can drag on for years, arbitration provides a lifeline for businesses that want swift resolution without getting bogged down by delays. The Arbitration and Conciliation Act of 1996 is the legislation that governs arbitration in India. It was modeled after the UN Citral Model Law on International Commercial Arbitration, setting out rules for both domestic and international arbitration. The purpose was clear: reduce the burden on courts by encouraging arbitration as the go-to method for resolving disputes. But as businesses and trade evolved, so did the complexities of arbitration. This is where the recent amendments come into play. In India's fast-paced and growing economy, arbitration holds a special place. Global businesses prefer arbitration because it offers speed, flexibility, and confidentiality, key factors that the traditional court system often struggles with. With these amendments, India is signaling to the world that it's serious about being an arbitration-friendly jurisdiction, positioning itself as a global hub for dispute resolution. This is particularly important as more international companies set up shop in India and want assurance that their disputes can be handled efficiently. Let's get into the nitty-gritty of the amendments, starting with some of the most significant changes. First up, the amendments place a strong emphasis on the appointment and qualifications of arbitrators. For arbitration to work effectively, it's crucial that the arbitrators involved are independent and unbiased. The new amendments ensure that arbitrators have to make full disclosures about any potential conflicts of interest, promoting transparency and fairness. The process for appointing arbitrators has also been streamlined. Gone are the days when arbitrator appointments would get stuck in procedural delays. Now, the appointment process is more structured and faster, which ultimately means disputes can be resolved more quickly. Also, the amendments set specific qualifications for arbitrators, ensuring that only experienced professionals with expertise in relevant fields handle cases. This adds credibility to the arbitration process and boosts confidence among the parties involved. Another crucial change is the timeline for arbitration. In the past, arbitration proceedings in India could get delayed for various reasons, which kind of defeated the whole point of choosing arbitration in the first place. The amendments tackle this by setting fixed timelines for completing arbitration proceedings. The idea is simple: get disputes resolved quickly so businesses can get back to what they do best. There are also provisions for fast-tracking certain types of arbitrations, meaning that if both parties agree, the entire process can be sped up even more. Plus, if arbitrators or parties fail to stick to the new timelines, they could face sanctions. Accountability is now front and center. Let's talk about two features that seem contradictory, but are both essential to a good arbitration system: confidentiality and transparency. Arbitration is favored by many businesses because of the confidentiality it offers. No one wants their sensitive business disputes aired out in public. The amendments strengthen confidentiality by mandating that arbitrators and parties keep all details of the proceedings private unless there's a legal obligation to disclose. At the same time, the procedural aspects of arbitration are being made more transparent, ensuring fairness and eliminating any suspicions of bias. So, What do these changes mean for legal practitioners in India? For starters, legal professionals need to adapt to the new timelines and procedures. Lawyers will have to get up to speed quickly and be more efficient with their case management, especially given the heightened focus on transparency and accountability. There are new opportunities and challenges for legal professionals with these amendments. On one hand, the faster timelines mean there will be greater demand for lawyers who can handle cases swiftly and effectively. It also opens up niche areas like mediation and conciliation, which could be additional services lawyers offer to their clients. On the other hand, the faster pace means there's less room for error, so legal professionals will need to be meticulous in how they present their cases. Plus, they'll need to stay updated with ongoing reforms and interpretations of the new act to avoid falling behind. For businesses, the amendments promise a smoother dispute resolution process. Quicker arbitrations mean less time and money spent on legal battles. This is particularly beneficial for multinational companies doing business in India, as the changes align the country's arbitration framework with global standards. But there are also cost implications. Faster arbitrations may lead to higher upfront legal fees, since everything has to be done in a shorter time frame. Businesses should consider reviewing their contracts, especially the dispute resolution clauses, to ensure they are in line with the updated arbitration framework. Finally, businesses should think strategically about these changes. The emphasis on speed and efficiency in arbitration means that companies need to be prepared to act quickly if a dispute arises. It's worth considering internal training for legal teams, so that they're fully prepared for the new processes and can respond accordingly. In conclusion, the amendments to India's Arbitration and Conciliation Act represent a major leap forward in legal reform. By improving transparency, speeding up the process, and enhancing the overall fairness of arbitration, India is setting itself up as a global leader in dispute resolution. For legal professionals and businesses alike, adapting to these changes is crucial. With the right strategies in place, these amendments could offer significant advantages in the long run. Thanks for joining us on Law Logical. If you enjoyed this episode, be sure to like, share, and subscribe for more in-depth insights on legal topics. Got questions? Drop them in the comments below, and we'll tackle them in future videos. See you next time.